And for this part of the program, we're shifting gears a little bit away from the market analysis, and we'll be looking at the issues associated with the policy side of real estate and development, land use, water law, subdivision regulation, some of the nitty-gritty growth policies and things that that really determine kind of how things can get built and what gets built, and kind of guides those market forces. So the format of this part of the program is we have three presentations from Alan McCormick, Mary Sexton, and Michelle Bryan Mudd. And each of them are going to do a presentation, and then at the end of that, we'll have all three of them up there, and we'll do a discussion and audience Q&A with the three of them around these issues of growth policy and all the legal, regulatory, and political issues that surround real estate and development in the region. So with that, I would like to introduce Alan McCormick. He's an attorney with Garlington Loan & Robinson, a trained and former planner himself, and extremely articulate and observant person on all the issues associated with this. So Alan, welcome.
Thanks. Good afternoon. This section for the next couple of hours is intended to qualify for continuing education for those of you who need continuing education. So the trick here is going to be to provide sort of a mixture of discussion that's going to be part education to qualify for the credit. But I did a presentation about a week or so ago on the Condominium Act in Montana and how you form condominiums. And I got the reviews back from it, and the top review of it said, not quite as dry as expected for an attorney, but still a really dry subject. And I couldn't tell if that was a compliment or if that was a comment, or I wasn't sure how to take it, but let's talk about something much more entertaining and interesting for this afternoon. And for the next 20 minutes, what I'm going to try to do is explain the growth management system in Montana, explain what's wrong with that system, and then give a pep talk about how to fix that system. And that's a lot to try to pack into the 20 minutes, but let's try the whirlwind approach. How do we manage growth in Montana? Well, first thing we do is we look to state statutes to figure out what the enabling authority is for managing growth. The granddaddy of all is the Growth Policy Act. Then we've got the Zoning Enabling Act. We've got the Subdivision and Platting Act. We've got the Sanitation and Subdivisions Act. And I'm going to throw a fifth one in there that a lot of you may not be thinking about, and that's the Montana Unit Ownership Act. And that's the Condominium Formation Act. That's how you do your condominiums. And in every condominium presentation, I make sure the one thing everybody learns is that condominiums are not land uses. Condominium is a form of ownership. But, as we'll see, the Montana Unit Ownership Act is taking on a much more important role in Montana with land use issues, because I don't need to tell you, condominiums in Montana are hot. And everybody wants to know how to form one, and everybody wants to know how to form one without having to go through subdivision review. But then we got impact fees, growth management tool. And this is really interesting. You know, the Growth Policy Act is Title 76, Chapter 1. Zoning and Enabling Act is Title 76, Chapter 2. Subdivision and Platting Act is Title 76, Chapter 3. Sanitation and Subdivision Act, Title 76, Chapter 4. You notice a nice little progression there, grouping all of those things together in a logical order. Then what do we do with impact fees? We stick them in Title 7. Anybody know where Title 7 is? That's over in the local government section of things. And we stick it in Title 7, Chapter 6, Part 16. That's the local government financial administration and taxation section. Well, impact fees are a growth management tool. What the heck are they doing over in Title 7? And then I took a look at Title 7, Chapter 12. This will boggle your mind. We've got rural improvement districts, special improvement districts, special provisions for special improvement lighting districts, special provisions for street maintenance districts, special provisions for street parking districts, fire hydrant maintenance districts, park maintenance districts. And I haven't even touched annexation yet. Well, this is how we manage growth in Montana. We have 5 major acts, and we've got a whole bunch of little acts about how we deal with the specifics of providing for financing of taking care of things. And you can put these into 2 different categories. First, you can look at the main acts of how do we approve development. That's growth policy, zoning, all of those sorts of things. And then you can look at the second category of things, which is how do we finance things that are already there but need improvement. You have development, you have roads that are substandard. How do you improve those things? Well, you might look at a rural improvement district. What's wrong? Every one of those acts has a different procedure. Every one of those acts has a different public participation provision. They have a different legal notice provision. They have a different adoption provision. But if somebody, and this is a comment you hear often, the reason growth management isn't working well in Montana is because we don't have enough tools. Well, good golly. I'm here to tell you we got tools. We got more tools than we know what to do with. What does Growth Policy Act do? Sets policy for Montana. Sets policy for individual counties, individual cities to say, this is where we want growth to go and this is how we want it to go about doing it. Zoning Enabling Act, what does that do? That tells us how do you carry out the growth policy. You enact zoning because zoning is regulatory, growth policies are not regulatory. Subdivision and Plating Act, what does that tell us to do? That's how you create your lots, blocks, roads, your design improvement standards. And then the Sanitation and Subdivision Act, that's how you satisfy your DEQ requirements. We got tools. We've got lots and lots of tools. So everything's right? Everything's comfortable. Everything's flexible. Everything works well, right? This is the trouble with the after lunch crowd. Everybody is kind of thinking about that good lunch. Well, you know and I know that that everything is not going well. And why isn't it going well? The acts don't talk to each other, right? What do I mean by that? The acts are not integrated. The roles are not well defined. The procedures are cumbersome. And here's the great part about all of it. Every 2 years, we get to figure out how to do it again. Because every 2 years, of course, is when our legislature meets and the legislature changes the rules on us. So, what's going on with all of this? We are spending an incredible amount of resources trying to figure out what the process is, and it's leaving us no time to figure out what the substance is. That's the problem with growth management in Montana. You know, when you look at all of these acts, Growth Policy Act, Zoning, Subdivision, Sanitation, Unit Ownership Act, Impact Fees, Rural Districts, to borrow a joke from one of my colleagues out here in the audience, you could collectively call these the Attorneys Relief and Compensation Act of 1973. I'm glad somebody's paying attention. So why does this matter? Well, it matters because it's a huge resource drain. Let me give you some examples. In 1997, we made a significant shift in Montana where we finally said, you're going to have a growth policy and here's what's going to be in the growth policy. In 1999, we added to that. In 2001, we added to that. In 2003, we added to that. 2005, we added to that. 2007, we added to it in 2007 as well. And so our planning departments are busy trying to figure out how to update their regulations to meet these new changes. And there's a bunch of planners out in the audience, and what the common refrain that you're hearing from planning departments is, I can't get ahead because I'm too busy catching up. Fair statement. So what did we do? We said growth policies are not regulatory documents. And you cannot turn down any land use permit based solely on noncompliance with the growth policy. A lot of folks say, that's terrible. And it's terrible because that means it has no teeth. Why are we spending all of this time and effort putting together a document that has no teeth? That's not terrible. Because if we integrate this and we consider that it's a total package of growth management tools, then we start to realize that a growth policy sets the broad policies. Defines generally what we want for growth in our communities, generally how we might carry out that growth. That's good. That's why they're general. That's why they tend to not have teeth. Where do you get your teeth? You get the zoning. And the zoning must be consistent with or made in accordance with the growth policy. Well, what's wrong with zoning? We have 3 ways of doing zoning. First, Part 1 zoning, citizen petition zoning. Citizens can petition to create a zoning district that then goes in front of a planning and zoning commission and the county commissioners, and it's a standalone district. It has no connection to any other zoning district in the county, which in itself has its own problems. Then we have Part 2 zoning, which is county down zoning, you might call it, where the county says, we're going to create zoning and we're going to create maybe a comprehensive type zoning, but we're going to administer it. And then you have Part 3 zoning, which is municipal zoning. This is how cities are going to do. Guess what? Each one of those has a different protest provision in it. Each one of it has a different adoption procedure in it. And we just went through this in Missoula County, and we're about to go through, we're going through it right now in Granite County. Nobody knows who gets to make the decision on citizen petition zoning districts. Is it the Planning and Zoning Commission that gets formed, or is it the county commissioners? We don't know. Let me give you another example. We have a problem with water in Montana, right? And that's something Mary's going to talk with us about. But we have a bigger problem in terms of whose role is it to evaluate water? And we went through a number of years of trying to figure out, well, the commissioners get to turn down subdivisions because the water doesn't look like it's going to work, or it looks like the septic systems are going to be have too much of an impact on the groundwater quality. The problem was county commissioners are not sanitarians. They're not engineers. They're not evaluating the rules, the specific standards in Montana law that the DEQ set through a public review process. And so they're making decisions based on policy. We think it's not going to work well. Bad idea. And so what did we do? We enacted 76, is it 622 or 620 that has the water requirements. And we created this long list of things that said, here, when you apply for a subdivision, you're going to put in this list of things to do with your water. You're going to show us what your proposal for the septic system is, what your proposal for the water is, some evidence that you have the water, and some evidence that the soils are going to work. But commissioners and city council folks, you're not going to make the decision on that. That's defining the role. That's good. So what did we do? We said, commissioners, you take public comments on that stuff, and you take the comments and you hand them to the developer at the end of the process, and the developer is to hand those comments on over to DEQ. Guess what we didn't do? We didn't go into the Sanitation and Subdivision Act and tell DEQ what they're supposed to do with the public comments. Well, Mary might know what they do with the public comments. I can hazard a guess what happens to those public comments, but I'll leave it to your imagination of where they actually end up. Montana Unit Ownership Act is another good example. That's how you form condominiums. And there's a nice little subdivision exemption in there. If you're in the city and you comply with zoning, you don't have to go through subdivision review to create your condominium. But you might have to go through DEQ review. But there's nothing in the subdivision or the Montana Unit Ownership Act that says go get your DEQ approval before you file your condominium documents at the clerk and recorder's office. So some clerk and recorders have gotten smart, and they have a checklist, and they say, before we will record this, we want you to prove that you satisfy DEQ requirements. Some of them don't, and you got to question whether there's even the authority for a clerk and recorder to do that when the Montana Unit Ownership Act has nothing in it about sanitation. There's some folks up in Big Fork that found out the hard way after they got their application or their condo docs filed, and then they got up and running. All of a sudden, DEQ appropriately steps in and says, "Hey, what about us?" So, well, we didn't know you guys had approval either. What's the problem here? Integration. or lack thereof of integration. The acts are not talking to each other. How do we fix it? Wouldn't be fair for me to criticize how we're doing things and the resource drain that it's creating with the processes without making some suggestions to fix it. I'm not entirely sure. But this room is filled with folks who are involved in this process. We've got bankers and realtors and developers and planners, all of whom are knowledgeable. I was going to say smart. Some of you may not think that of your colleagues, I'm not sure, but you're knowledgeable about what's going on out there, and collectively we've got to be able to fix this. Here's the first thing. Stop the Band-Aid approach. Every 2 years we stick a Band-Aid on the Subdivision and Platting Act. And it is fun. Only an attorney in land use could think this was fun. But you can open up the Subdivision and Platting Act and you can go code by code and you can say, yeah, that was the problem in Flathead County. Oh yeah, this happened in Granite County. You know, Flathead County spent a time in the 1990s turning down subdivisions because of educational impacts. Their schools were full, they were overburdened, they didn't have any more capacity. So, hey, if we approve your subdivision, that's going to overwhelm the school. Let's turn it down. So now there's a nice little provision in the Subdivision and Platting Act that says you must consider all of the effects on public health, safety, local services, education, all of that sort of stuff. Then there's a little line in there that says, but you can't make them do anything about education. So what do? Well, we say, Mr. Developer, we can't make you pay for a new school site, but gee, it would be really nice if you would voluntarily agree to do that, right? And Ravalli County is even undertaking a study that at least I've read about it, I haven't heard about it from them, but they're undertaking a study to figure out what is a reasonable amount of voluntary contribution that we should be asking all of our developers to contribute because we're tired of making an on-the-spot decision during the process. Wow! Talk about your resource drain. We've got an impact fee section for some of the development impacts and a process to go through all of that, but are voluntary contributions really voluntary? I'm not so sure. We need to stop this Band-Aid approach. We need to stop every 2 years going into the Montana or the legislature and asking them to apply Band-Aids to what we're looking at. We need a change of attitudes. You've heard of bananas? Build absolutely nothing anywhere near anything. They're the new NIMBYs. Collaborative processes work much better. And there's a great example going on in Missoula County right now with Plum Creek. A very large, actually the largest landowner in Montana, who has chosen to say zoning is not a bad thing. Adequate, appropriate zoning done in cooperation with the Seeley Lake Community Council and Missoula County will have a positive net effect for everyone. That is a huge shift in attitude from, in one case, a significant landowner, but also in terms of the community of realizing the discussion is not how do we preserve the status quo, but the discussion is about how do we accommodate the growth that we know is going to occur here? And we can do it proactively, or we can let nature take its course, you might say. So there's a change of attitude that needs to occur here in terms of how we go about doing the growth. Neighbors need to stop thinking they have veto power and start realizing that they have collaborative powers. And developers need to stop thinking in terms of ultimate entitlements, that I just get this and I don't have to work with the process or be respectful of the neighborhood. We need that change of attitude. We need to define the roles. Missoula City right now is going through a comprehensive update of their zoning codes. These zoning codes were created back in 1973, and they're terrible. Almost everybody on all sides agrees that they're terrible. Why are they terrible? Because we don't know what everybody's role is. And the rules, frankly, don't comply with state law. If you want a parking variance and you are not a historic building, you go to the Board of Adjustments. If you need a parking variance and you are a historic building, you get to go to the Historic Preservation Commission. Well, I'm here to tell you, state law says, maybe I shouldn't mention this, state law says the only entity with the power to grant variances is the Board of Adjustments. So why, for the last 25 years, have we been going to the Historic Preservation Commission, which is not set up to evaluate variances? If you want a conditional use permit, you go to the Design Review Board. Design Review Board does not work well with conditional use permit. These are roles that we have asked boards to take on that do not make any sense. Well, first, they don't comply with state law, but second, they just don't make any sense because we're not providing boards with the tools they need and the well-defined roles that they need and the criteria that they need to make decisions. How do you fix that? Critical analysis of every piece of legislation you enact. Look at what problem is it that you're going to fix first? But then you look at who am I giving the power to? What power am I giving them? And what criteria am I providing them to enable them to exercise the power that they're given? And I got to tell you, where we're breaking down in that process most often is the lack of criteria to guide that decision making. You go into Missoula City's conditional use permit, and there's a long list of considerations, none of which are criteria, and it leaves the Design Review Board with no criteria to make its decision. And then we're doing things that are silly, like residential development in downtown Missoula is a hot thing, or it would be a hot thing if our code didn't require every development greater than 16 dwelling units per acre to go to a design review board. That lacks criteria to make the decision. So it's kind of stymieing development because our codes are not encouraging the type of development that we want. The beautiful thing here is that Missoula is undertaking the comprehensive evaluation of their zoning, and we have an opportunity to fix that. Let me talk about the broader scale, though. Why do we have three ways to do zoning? Well, historically, we had three ways to do zoning because there's been this tension between agricultural counties and urban counties, and the ag counties were really afraid of relinquishing power, and they didn't want to be treated like the urban counties, and so we end up with three ways to do zoning. Well, Missoula has a consolidated planning department, so somebody in there's now got to be cognizant and always being paying attention to, okay, if we do zoning this way, if I got a project in the county, I got to do it this way. If I'm in the city, I got to do it this way. If the citizens come in and do it, I got to do it this way. And why are we doing that? We need to figure out how to define the roles and define the procedures that make sense, that reduce this process. Why do we want to reduce the process? This is not an advocacy, or I'm not advocating greasing the skids for development. Some of you out there would say that there's too much grease already. What I'm advocating is spending less time on the process, trying to figure out which rules do I apply, did I do them right, are we going to get sued because we can't figure out which zoning board actually is supposed to hear this thing, and more time on figuring out what the substance is. Is this subdivision a good idea? Does it meet the rules and regulations? Is this where we want growth to occur? And is this the way we want to implement that? We need funding. Every other legislature, it seems like, we have a bill in place that says, let's provide $1 million, $2 million or something for local governments to be able to do planning. I'm telling you, $1 million to $2 million is not enough. It doesn't even scratch the surface. But there was also a real question about, shouldn't that funding be generated locally? Because if it's our counties who are funding these things, aren't the people in the counties going to be more behind it because it's actually their money and not this collective pot of state money? It's a good idea, but growth in Montana is we're all in this together. We may do things differently in Missoula and Ravalli and Flathead County, but we're all in it together, and we need to fund a process of fixing these global regulations and allowing communities the time to do the policy setting regulations. We need to do a global approach to managing growth, and this is I just got the high sign down here. You guys probably can't see the cue cards down here. I've got the high sign. So I'll wrap it up by saying we need to look to do a global approach to managing growth in Montana. What do I mean by that? Integrate, get the acts to start talking to each other. We need to define the roles, and we need to simplify the procedures so you're not having to hire an attorney to figure out, okay, if I do part 1 zoning, which is different than part 2, it goes, yeah, I got to form this planning and zoning commission, and then does it go to that planning and zoning commission, or do they make a recommendation to the county commissioners, or does the county commissioners do this? That's what we're doing in Montana to manage growth, is we're spending all of this time and resources figuring out what these processes are, and not enough time figuring out what the substance is. So my topic, obviously, is one of a global look at Montana's land use regulation scheme. The tools are there. That's the positive thing. This is not a gloom and doom speech. The tools are there to get it done. We simply need to make the tools talk to each other. We need to simplify them so we can get to the substance. With that, I'll turn it over to you, Jonathan.
Thank you very much, Alan. I think that was a very good brief on kind of not only what's wrong, but why it is that when you look at this process as a layman and you kind of wonder why you can't understand what this process is, you can take comfort in knowing that it's not because you're an idiot. It's because the processes are very confusing, and some good suggestions on how to get around them. Excuse me. And next, I'd like to introduce Mary Sexton, the director of the Montana Department of Natural Resources and Conservation, and she'll be talking especially about water and also about fire, 2 very hot issues. Mary?
There we go. Good afternoon. Yeah, I am Mary Sexton, and I direct the Department of Natural Resources and Conservation, which is different from the Department of Environmental Quality. So just to make that clear at first, and we both deal with growth issues in Montana, but primarily, if you're looking at the state level beyond the counties, it is the Department of Environmental Quality. As a way of introduction, I think many of you folks who have lived in Montana for the last 20 years, and I've lived here most all of my life, recognize that there have been some substantial changes in Montana. During the 80s, I actually lived in Ravalli County and served in the Ravalli County Planning Board in 1984 through 86. And Ravalli County in the 80s went through from a population, I think when I arrived in the late 70s, of 12,000 to 15,000 people, and by the time I left it was 25,000. I know there's some Ravalli County legislators here, and I think Ravalli County is probably 35,000 people now, if not heading towards 40,000 people. It's grown substantially. The growth in Montana, I think, particularly in the larger counties in western Montana, is obvious even to someone who's more of a newcomer to this part of the state. And how are we dealing with this? What are some of the pluses? What are some of the minuses, obviously? And that's what part of this conference is about. A few numbers. The Department of Environmental Quality, who does do sewer, septic, and water review for subdivisions in Montana, has over the last 10 years approved 70,000 lots. 70,000 lots. And just to give you an example of this rapid rate of increase, in the last year, 2006, it was 10,000 lots. So it's not only a lot in the last 10 years, but it's escalating, it's increasing. And because my department doesn't oversee some of those regulatory items, I would like to talk a little bit about water and what part that plays in subdevelopment Montana, and what kind of impacts it may have, and really what challenges we face when we look at water development, water availability, and water quality. As some of you may or may not know, water resources in Montana, that is the water that we have, belongs to the state, except those rights that are reserved to the federal government. I'm not going to get into that, it's kind of confusing. But the water belongs to the state, and you as a water user have the right to use that water. And we're going through an adjudication process right now, which means we are going through the over 300,000 claims to use water in Montana, and determining through a review process and finally a judicial process in the water court just who has the right to use that water. This is very, very important. Whether you're an ag user, whether you're a municipality, whether you like to fish, it's very important that we know who has the right to use water in Montana. And this is an effort that's being speeded up right now. We've hired extra folks in DNRC so we can review water rights and we can have a completed adjudication within the next 10 to 15 years. And as that's going on concurrently, and I think it's probably also not a surprise to any of you, Montana has had a substantial drought last 7, 8 years. We have lost a year and a half of water. When you look at annual precipitation, you look at where we are compared to the annual averages, we've lost about 1.5 years of water. More substantial in some places than others, but it is a fact of life and it has its impacts. So we have a drought, we're going through the adjudication process, and we're also experiencing very rapid development, rural residential development in certain parts of the state. So there are challenges when you look at those three things together. One of the issues that's, I think, on the front burner for water is the connection between groundwater and surface water. And I did bring some posters with me, not realizing really quite how large this group is. You'll have to look at them during the break, but I have one poster that shows the groundwater development in Ravalli County between 1973 and today. And even if you're sitting back a ways and it's over here, you can look at the little red dots, and they have multiplied substantially in the last years. So groundwater development, how does that impact surface water? And in fact, there was a piece of legislation passed in the last session called House Bill 831, which has been fairly controversial, but it gives us a permitting process, particularly in closed basins where experts and legislators have decided, hey, there's no more water here, we've over-appropriated, let's close the basin. But it's how folks can apply for new water in closed basins. And that does apply to an awful lot of western Montana. And we're just working the kinks out of that. It is a challenging process, but I think it's an indication of really how critical how our use of groundwater, whether it's through larger permitted wells or through the use of an exempt well, what impact that can have on our surface waters, particularly in drought periods. And I guess the next thing I did want to talk about was exempt wells, because I think many of you are involved in the real estate business, or maybe many of you, some of you may be involved in agriculture, and a lot of us like to recreate in Montana. An exempt well is basically a free water right. As I said, there are over 300,000 water claims to water in Montana. But if you have an exempt well of 35 gallons a minute, 10 acre-feet or less, which is really a substantial amount of water. You know, you can irrigate pretty easily a 5-acre lot, as well as have plenty of use for your home use. That is given through state statute to anyone who completes a well and sends in a certificate of completion to DNRC. And it's sort of interesting, and if you look at the chart over here that shows the numbers of lots in Montana as they're increasing, again 10,000 in the last year, ironically, the number of exempt wells is increasing in Montana almost at the same rate. Because in many ways, for developers to use the exempt well exemption, which is fairly easy, it's the purchaser of a lot who uses it, is much easier and much less costly than going through the permitting process, which I have to admit can be somewhat onerous. The previous speaker talked about that. To get a permit to either change a use from irrigation to municipal use, or to gain a permit for a community well, which is more than 35 gallons a minute. It takes some time. You have to hire often consultants and maybe attorneys, and there can be objections to the process because this well might impact another water user. So it does take some time through this process. So many times the use of this exempt well opportunity is the preferred choice, particularly when you're looking at rural subdivisions. Initially, this was intended for more isolated or not such concentrated use, and quite frankly, the use of an exempt well, one by one, is not substantial. But as a comparison, if you have a 300 lot subdivision, 300 homes, which when we have 10,000 lots that are reviewed a year, that's not a whole lot, that uses approximately the same amount of water as 160 acres of irrigated alfalfa. Now, if any of you are in the ag business out there, you know you can't get a free water right if you decide you want to put a sprinkler on 160 acres of alfalfa. However, if you are a developer and you have 300 homes that you put in a particular area and you decide you don't want to get a community water system, you can require your new homeowners to put in 300 exempt wells. Free. And so I think this is something that it's a challenging issue, and it's something that I think needs to be considered. Where is it appropriate to use exempt wells? Should there be a permitting process for exempt wells? And the other issue I think that, particularly in the Helena Valley and also in the Gallatin Valley, is becoming more and more obvious is water quality issues. Often these wells, particularly exempt wells, are very shallow wells. And if you have quite a bit of density in homes, sometimes you have problems with your neighbor's septic system leaking into your well system. I don't think I'm surprising anybody to say this, that it does actually happen. And that's a very difficult thing to regulate. Again, this is the septic system regulation is under DEQ. We have no regulation of exempt wells other than they fire a certificate of completion. And so it is in some areas becoming a very real public health problem, and it may even be a water quantity as well as water quality problem in the long run. And I don't want to be an alarmist and say, hey, the world's falling in, because it's certainly not. But I think as we look at more substantial development in Montana, and even dealing with the development we already have, that we have to be cognizant of what these longer-term impacts are going to be. There is, through the legislature, in fact, I just came from Shoto this morning, a water policy committee. I think that the legislature is very obviously recognizing the importance of water. That water really is the liquid gold for the next century, not only for municipalities, for subdevelopment, but for a multitude of other uses, conservation uses, agricultural uses, and incidentally, agriculture is the largest user of water in Montana. I don't think that's a surprise to anyone. Well over 90% of our water is used by agriculture. So the legislature has put together an interim water policy committee. A lot of the associations were there this morning, from Trout Unlimited to the realtors, and a lot of folks in between. They go to these meetings regularly. They're meeting on a monthly basis, and they've been looking into groundwater surface water issues, water quality issues, injection wells, exempt wells, a lot of issues that to some folks may be a little sleepy or sleep-causing, but really very, very important issues. So if that's something you'd like to follow, if you look on the legislative page for Montana, it's the Interim Water Policy Committee, and they are looking at water issues. And I would say that also they're looking at creative solutions. Again, this isn't all gloom and doom. There are solutions out there. Other states have water banking for mitigation. There are different sorts of approaches that can be utilized, and I'm hopeful that by working with the many interest groups, along with agencies and communities, of course this is a very poignant community issue, that we can find creative solutions to the many water impacts that come with continued development in Montana. Another issue that I guess is, I wouldn't say near and dear to my heart, but I certainly deal with it in my agency quite a bit, is wildland fire. And again, wildland fire is something that is with us, and it's maybe a little more prominent, and we see it more than we do the water-related issues. But with the extended drought, our old friend drought, and with forests in which fire has been suppressed for a number of years, it's no surprise that we're having a substantial increase in wildland fires. I have a poster over here, and again, you can look at it during the break. The last 2 years alone, we've burned up almost 2 million acres in Montana. That's pretty substantial. Some of that is in very remote areas, wilderness areas, and so on and so forth. But by our statistics at DNRC, over half these fires are in what we are affectionately call the WUI, the Wildland-Urban Interface, and I'm sure a few of you folks have heard of that. So as our forests are in need of attention in some ways, we're experiencing drought, and we do have fire, and particularly in the Wildland-Urban Interface, and that presents us with a lot of issues as far as fire suppression. How do you deal with homeowners there? We've had a number of conversations with counties because this is a planning issue. There are hazards in the wildland-urban interface. If you decide you want to live in a forested area where there's not very good access, you like a lot of trees around you, maybe you don't have water availability for suppression, whose responsibility is to take care of you and your house when the fire comes? Well, obviously, it's the DNRC and your local fire department. Maybe it's the federal government if you're close to federal lands. How about your insurance company? What about you? The governor has been very directed in his statement saying that you're the first person that can really protect your home. And this is something from an educational perspective that we promote certainly through DNRC, is the building of defensible space, having good ingress and egress, having a water source. I think to those of you that are planners or those of you that are developers, you've heard these things before. And in fact, in the last legislative session, there were a number of bills dealing with the wildland-urban interface. Some of them were planning related, and we do in fact now have a Senate Bill 51 that we're working on. And within the growth policies that each county commissioner is going to have to at least take a look at, each county commission will have to look at the wildland-urban interface and see if it's a hazard in their county. And if it is, we as a department and working with our interest groups are developing a set of best management practices that then the counties in their growth plan management and their growth policies may adopt, which again is not regulatory, but may adopt in their growth policies. And if they so desire, they can even adopt these into their subdivision regulations, and if they so desire, they can go a step further and adopt these into zoning, which some counties have actually done. Because I think counties and local jurisdictions are beginning to realize that the wildland-urban interface is a serious problem from a liability standpoint and from an expense standpoint. And speaking of expenses, those of you from Montana, I think many of you are, we had a special session just a little over a month ago, and my department was fortunate enough to get $80 million over the next 2 years. Believe me, that's a chunk of change. Montana has chosen not to directly fund fire suppression. We've always begged, borrowed, and then at the next legislative session, we hope to get reimbursed for whatever we spent to put out fires in Montana. And last year, the bill was $35 million. We got paid back by the legislature. This year, due to another number of circumstances, we went through the governor's reserve fund, and we were still really short. We had to call a special session, and the legislators realized that they need to start paying attention up front to fire suppression funding, and we got $40 million, which is about the tab for this year. And this is state only. When you look at the federal tab and even what local jurisdictions have had to put into the mix, it's well over $100 million this year in fire suppression. So we got $40 million this year, and we also have a kitty for next year. We hope it isn't going to be a year like this year, but when you look between 2000 and 2007, 4 out of those years have been substantial fire years with bills over $20 million. So it is a substantial challenge for us, not only as an agency, but communities, homeowners, and folks who are in the real estate business, folks who are in the timber business. It is something that does impact all of us, and we need to look at the challenges that presents. I think there are maybe some statutory changes that can be made, but I often think that until there's a real realization that there is an issue out there, that there is a problem, and that we are living in changing times, that sometimes the statutory changes are a little too late, and as the former speaker said, sometimes so complicated that they're very hard to implement. So I guess in closing, I'd like to say that given the challenges that we have in water and with wildland fire, there are issues out there, and they're complicated, but there are hopefully solutions. Looking at growth policies, looking at funding opportunities, whether it's for fire suppression or for water system development, we need to look creatively at that. But we need to ask ourselves, who should be at the table in making these decisions? Is it local jurisdictions? Is it state agencies? Is it interest groups? Who makes these decisions? Can we do these things quickly enough? I think when we honestly look at water challenges in Montana as well as fire, we're almost too late in some ways. We really have been dealing with these for the last 7 and 8 years, maybe not as well as we might, and we need to hurry up and figure out how we're going to address these issues in a pretty quick fashion. And most importantly, when we look at all these things, we need to determine what are the economic realities of water development, water use in Montana. What are the social impacts of wildland fire? You know, if you look at California, it's in the news right now, and the social impacts of 1,800 lost homes, and I think over 1 million people displaced from homes, there are huge social and economic impacts. And lastly, we need to consider what the environmental impacts are of over-appropriated streams, dried up streams, contaminated water, forests that have burned. There are impacts there. And so I think we need to look at all these things very seriously and hopefully in a collaborative fashion so that we can find creative, realistic solutions to our fire and water challenges. So I do have, again, the posters. Please take a look at those, and later we have time for questions. So I thank you very much.
Thank you very much, Mary. Certainly the point about social impacts, we all talk all the time about the amenities and quality of life and the reason that real estate and development is happening, but of course if there are no fish in the streams and smoke in the valley all summer, that is a huge issue, I think, for all of us. Our next speaker is Michelle Bryan Mudd, who is a professor of law at the University of Montana Law School, head of the land use clinic there, and she's going to try to bring together a couple of these themes and look at how water law and land use law can kind of better work together. So, Michelle?
Well, when Jonathan invited me back to speak this year, he gave me permission to be what I think of as a lawyer unplugged. I don't have to go through line by line through land use laws, but I can actually think outside the box because of all of the people that are here that are thinking outside of the box. And so I put together some materials so that when I do refer to a law, you have it in front of you and you can look at it. But we're not going to dwell entirely on what the law is today. You will see in the materials that after a law is set out, there's an empty space. And what I want to focus on for the next half hour is the empty space and all the possible ways that we could fill it up. And my focus today is to try and tie together two very separate systems from the law's perspective. The systems of land use governance and water use governance that have evolved quite separately in the legal world, even though in reality, land and water are very tied together. So we're going to talk about what the laws are today very briefly, but then we're going to talk about what they could be, which in order to envision what they could be, we all have to think about it together. The first thing I want to talk about is why land and water turned out to be these two separate things. And you've already heard Mary and Alan talk about how different agencies are involved, different levels of government are involved, and how confusing it is for everyone. So why did it turn out that way? Well, water in the West evolved from one social environment which came out in the 1800s when the miners came here and they needed to take water away from the place that it was occurring to use it in their mining processes. And that's how we got the prior appropriation doctrine and the need to have ultimately a state agency to decide what rights are in Montana. But the result of that doctrine and a result of a lot of federal policies that encouraged homesteading on dry lands, right? That weren't necessarily near a water source. The result of that was a detachment from the land. The water became detached. It became movable. And the priority focused the user on taking it first, using it so I don't lose it. And so it really pushed our water world into a society where consumption and movement was the most important thing. And after the West started becoming settled and water was getting moved around and everyone was competing to be the highest, earliest user, that's when land use planning evolved. Almost a century later, when communities started bumping up against each other, there was suddenly a need to regulate how people used it. And that power to regulate how people use land was given to local government, to community. And the focus was on human activity on the land. And a different legal regime evolved there. So we turned into a society that had state control of water and local control of land, and they've been separate this whole time. So there are the vertical disconnects, but then there are also the horizontal disconnects. Not only is it state and local, but it's county by county, city to county, and so it's hard to envision or think about how the way we use our land should relate to water that crosses all of those jurisdictional boundaries. And different expert cultures evolved out of this. Land use planners that think spatially. They think about maps and drawings and diagrams and traffic data. And then you have the water regulators that are thinking about things quantitatively, directionally, acre feet, units of time, direction of flow. So we've got not only two different legal regimes, but two different cultures, and a real need to tie them together. Why do we need to tie them together? These are my exhibits. Exhibit A, the New York Times Magazine last week, cover of it reads, "The Perfect Drought, Why Population Growth and Climate Change Leave the West Without Water." It's an excellent article. It's on what's happening in the West, and it touches on a lot of the data that Mary mentioned, and the types of water crises that are on the horizon due to the increased growth in the West. Now that article focuses a lot on places like Nevada, New Mexico, Arizona. So I think, does it apply here? And that might be a reaction that a lot of you have as well. Is it relevant here? Exhibit B, Montana Magazine in August, talking about the climate data in Montana and the Rocky Mountain West. The same issues are coming here that are more poignant already in places like Nevada and New Mexico. And that article suggests that the seasonal timing of water management in Montana is going to dramatically change in the next decade. In fact, moving when the peak water flows occur up 3 to 6 weeks from where they are now, leaving stream beds dry during most of the summer months, creating sterile aquatic environments, and having instead heavy sporadic waterfall occurring because of the climate change. The other issue, and Mary touched on adjudication, the other issue that's happening in Montana is as these adjudications unfold, and they've unfolded quite slowly over time because of the level of resources that have been provided to the department. But what we've realized is that a lot of the original claims that occurred when people claimed their water right happened at times when our water level was at a peak, according to water data. And so now when the adjudications are occurring, we have a much different level of water. So we're developing land in a time of uncertainty about the amount of water we have, and we're developing it locally while a state agency is ironing out what the permits are ultimately going to be. In the meantime, we have a legacy of sprawl development that's unfolded in many places around the West that actually encourages very high intensity water use. We have large grassy setbacks. We have nice golf courses. We have beautiful non-native landscaping. And we have very long distances that we have to carry water through to get to the developments we've created in the West. So we have these very different systems, and we need to somehow begin to pull them back together. And what I'd like to focus on is how locally we can do that. There are a lot of different solutions, but locally, how do we begin looking at our communities in a way that when we picture a new development, we also in our mind picture the entire water capacity of the basin that we live in and how that development has a relationship to that water capacity and to all of the important water uses in our community and how we want to prioritize those water uses and have a say in it quite locally. And I think the local process is really where the solution needs to begin. Now, geologists and hydrologists and climatologists, they've been thinking about real estate development and water use together for some time. But lawyers, as you might guess, are a little slow in having an idea dawn in their minds. So in the legal arena, people are just beginning to talk about how to merge these long, separate laws. And the best book that I have found, which I wanted to recommend to you, is a book called Wet Growth. And it asks the question, should water law control land use? And it's a collection of 10 essays by legal thinkers around the country, and it's edited by Craig Tony Arnold. That's the only book out there on the topic right now in the legal arena. But as you know, the law is only the tool to implement the idea that will come, I'm certain, from someone besides a lawyer. So what I want to do now is walk through some models of what other places are doing. And I want you to set aside some of your skepticism. You might, as you hear these ideas, think, oh, that's expensive. Oh, that places a burden on the wrong person. Or, oh, it's just too hard to implement here. What I want you to do is set that aside and just listen to the ideas, knowing that they won't all work for every community, but knowing that it's good to be aware of them. The first model, which is set out for you on the first page of your packet, is the California model, and it's really held out as, in legal communities, as the most large-scale merging of land development and water use. And there are a series of tools bundled together in California now that try to force communities and land developers to start thinking about how their development is going to impact the availability of water in their community. So the first tool is the Urban Water Management Planning Act. And this is what it asks every municipal water supplier, every urban water supplier to do, to prepare a plan that addresses the carrying capacity, the source of supply, the efficiency of practices, and the specific projects and projected water demands for 20 years out for that community. They have to sit down and think out the next 20 years, all of the projected growth in the community and how they're going to meet the needs of that growth. There has to be a plan, a big picture plan. Not just current population, but projected population and how climate might affect the reliability of the water supply. And it looks at both surface and groundwater. The water supplier has to talk about how it plans to explore efficiency measures, water recycling opportunities, and that water supplier is obligated to coordinate their plan with any other supplier that shares a common water source. So what unfolds then is a statewide set of community water plans that looks out 20 years in five-year increments. Now, at the local level, what a developer has to do when the developer proposes a development is do a water supply assessment based on that water supply plan. Using that community plan, a developer has to show that there is water availability for the specific project the developer wants to do. And this happens at the preliminary approval phase for the development. Now, we've heard a little bit about Section 763622, which sort of asks developers to do that in Montana, but this is much different. It actually requires a lot more detail, and it doesn't allow a handoff to a state agency. It requires that the local government assess the supply availability and whether it's there for the project. And then, before final map approval, the developer has to show a water supply verification. It's a condition of the final map approval, and the developer has to show that there's sufficient supply for 20 years out, not just for normal years, but single dry and multiple dry years. And it's not just for that project. It's in light of existing and planned future uses in that planning area, and it takes into account existing agricultural uses as well. Before they can develop, they have to show all of this information. But remember that the community's already done a lot of it for them with that community plan for the water supply system. And there's a test case, which I lay out for you, called Vineyard Area Citizens for Responsible Growth, that interprets these provisions. So if you're curious about how the court has interpreted them in California, you might enjoy reading that case. It talks about what the water supply assessment needs to do, and it imposes a sort of standard that the developer has to show a reasonable likelihood of actual availability. Doesn't mean it's certain, but a reasonable likelihood that the water will be available. What the developer can't do is assume that water will be available based simply on the assertion that there might be a paper right, a paper water right. And that's where, in Montana, it becomes difficult. How do we show that availability in areas that have not been completely adjudicated by the state yet, and we're not certain about the strengths of the surface water rights we're relying on? So that's what's happening in California. And it certainly isn't working perfectly there. It only applies to fairly large developments, 500 units or more, businesses with fairly large square footage. But it's definitely a first step at integrating the two regimes, the land and water. Then there's the Hawaii model, which I'll talk about very briefly, that integrates land and water as well. And it does it in a very different way by relying on something called the public trust doctrine. And Mary told you, in Montana, waters are owned by the public. And closely related to that concept is the public trust doctrine, which is honored in Montana, which means that ultimately government has the duty to ensure that the water is used in a way that benefits the needs of the public. So in Hawaii, what is happening under that doctrine and regulations implementing that doctrine is that when traditional water rights are freed up, their state approval agency and their hearings board has to prioritize for those freed up water rights what is in the public trust for that particular area. And so in Montana, for example, we have a list of all the beneficial uses for which water can be used, but they aren't ranked in any way. So as long as your use is on that list, you're fine. But in Hawaii, they started ranking, and not on a statewide basis, but on a local basis. What use is most important? How much do we want to set aside for ag? How much do we want to set aside for residential, for commercial, for emergency services like firefighting or hospitals and schools? So they've started prioritizing how they want to use water. And so by prioritizing in that way, they've also prioritized and quantified the amount of development that could occur in that particular community under those priority categories. I put in as well some non-regulatory models, like the Blackfoot Challenge, which is often referred to in Montana as a wonderful model where the community has gotten together in a private way, working with private and government entities to manage the water and land uses together. And Mary also talked about water banking. We don't have that in Montana. We don't have a regulation authorizing it. But with water banking, people can start putting in their extra water rights and other people can start buying them without going through the extensive change of use process to which Mary referred. I put those in as models because it really takes all three. And those non-regulatory models are often the ones that give us the speed we need. As Mary noted, the regulations can really bog down the process, and trying to change them takes a long time. So by integrating, really, if you look at the models, regulations with court rulings and private solutions, you see all the different players that have to be involved to really make the land and water connection occur. So what do we want to do then in Montana? If you turn to page 2, the first thing we need to do is use that planning document, that growth policy that Alan was talking about. And I put there for you the contents of what need to be in a growth policy in Montana. And they're fairly broad. But what I want you to know is that right now local government has the power to decide that they want to do a community water plan. It may not be as huge and intricate as the one in California, but within a growth policy, a community can put together a plan for what they think is their water capacity. What is the supply capacity for our community? Assess the quality of it. Assess the groundwater, surface water hydrology in the local basin. Evaluate the climate impacts and the supply variability in that community. Connect the supply capacity to land use models and other goals in the plan. Affordable housing. How much do we want? Where should we put it? Connect that to the water supply. Do we have the supply to do the affordable housing we want to do? Have that water plan look at different time horizons. Let's look at 5 years from now, but let's also look at 20 years from now and force ourselves to have that level of reflection about what we're doing. It can have specific action items in it to implement the ideas of the community's water supply plan. You can revisit the supply plan frequently. It doesn't have to be something that you think about and put away, and it shouldn't be something that you think about and put away. And it can empower you to then go out and share your plan with other communities that share a basin with you. And look at their growth data and connect it to capacity. You can use that information to assist state agencies like the DNRC, the DEQ, and the Water Court that are all making statewide decisions that are affecting you, that are affecting the basin you're in. And they're right now doing it very independently. So to the extent the community plans and is intimately familiar with the growth that's going to happen and the supply that they have, they can be a stronger participant in the state processes. And that plan can help you prioritize in your community what are the beneficial uses that are most important to you. So to the extent there is municipal water supply, how do you want it to be used? This isn't really going on right now in Montana communities, and I think it's the first step, the foundation for everything else. Doing this community planning also forces everyone to be a participant, right? People that live here now, and then people that are going to come in later. If you look at page 3 now, that's the plan, and then as Ellen mentioned, you can implement this plan, this water supply plan, in various ways. Again, you have the power to do it now. I lay out for you the statute that describes the types of things that zoning can cover, and that list certainly covers the provision of water supply in the community. Next, I lay out the subdivision regulations that enable local government to regulate subdivisions. Those also focus on water supply and delivery. Also, the contents of environmental assessments that must be put together for most developments in Montana, which include a description of the body or stream of surface water affected by the proposed subdivision, together with available groundwater information. Imagine how much more thorough that EA could be if the community had done a plan on which developers could then use when putting together their EA. So you've got the power to make these more integrated. And I'm going to spend just a few minutes now throwing out some of the ideas that I've culled together of other places that have implemented things at the local level. You may have heard a lot of these ideas before, but I'm going to put them all together in one place. Think about which ones jump out at you and what you could bring to this idea. Creating zoning that protects areas that need to have permeable surfaces. Impermeable surfaces are one of the largest ways that a community throws out its innate water supply. In a study by Smart Growth America, which studied 20 cities with high growth around the US, the study said that, just for one example, the city of Atlanta had so much impermeable surface that it lost between 57 and 133 billion gallons of water a year. So just thinking alone about protecting permeable surfaces in some way would keep water in your community that it would otherwise be washing away. So thinking about the type of soil, looking at the places that have particular runoff patterns, proximity to water, thinking about buffers, non-traditional buffers perhaps, that could be used to protect permeable surfaces. And this seems logical, but when you balance it against a lot of the other smart growth approaches that are saying infill, create tightly dense areas, we might want to reflect on those again and ask ourselves, do we want infill everywhere? Or are there places that we want to protect so that we keep the water quality and the water quantity that we need in our particular basin? Think about discretionary permitting, which allows site-specific tailoring of community needs, that would allow communities to work with the landowner on appropriate mitigation measures that would mitigate the amount of water use occurring. Maybe it's the design or structure, or maybe it's behavior on the property. So creating water conservation behaviors, permeable pavers, appropriate landscaping, using water-saving devices in the structure itself, using reclaimed water. Think about standards for evaluating the watershed impact of development proposals. Real measurable standards for both now and in the long term. And again, reassess our incentives. Do all of our smart growth incentives mesh with our need to protect our water supply? And of course, reward landowners for things that they're doing well. If they're using best management practices, perhaps let them have a little more density. Perhaps let them have increased building sites. Reward them for participating in innovative partnerships like the Blackfoot Challenge. The next statute you'll see in your packet is a subdivision regulation that actually requires individual landowners, and this really applies when you're converting an agricultural property to a development. It forces them to go through a thinking process in dealing with the water rights on the property. And I see this as a small model of how we could start integrating it, so that we also ask developers to not only think about dealing with water rights that might be on their property, but just in general, thinking about how they're going to supply water to their property in light of not only the needs of their property, but all the projected needs of the community, as the developers have to do in California under Senate Bill 610 and 221. The last thing in the packet I call closing the gap. One of the gaps is actually in the environmental assessment statute that's in the packet, and that gap is that minor subdivisions don't have to do an extensive environmental assessment. Minor subdivisions, as most of you probably know, are 5 lots or less. I question whether, even though it may be appropriate to have them exempt from a lot of subdivision review, I question whether there shouldn't be some type of water assessment, regardless of the size of the lot, because of the cumulative effects that Mary talked about. When you start adding all of these minors together, it becomes a very major issue for a community. And we've already talked about the groundwater wells as well, and how there is a large exemption right now in the permitting process, so that basically the traditional water rights holders like ag, like municipalities, can see their water resource drained away by these individual wells and not have any control over it. And it's a gap that needs to be closed. And actually, the legislature considered closing it this last session in a bill called HB 262, which died in standing committee, I believe. And that bill, I think, struck a nice balance. It didn't eliminate the exception, but required in growth areas, areas that had a population of 30,000 or more, or were experiencing large population increases of 10% or more, to go through the permitting process. So those are a few of the ways that I see we can begin in very small ways to integrate land and water and empower communities to have a larger say in what's going on with their water. So it's not a disconnect where we're handing off all of our water questions to state agencies, but we're working together with them based on our goals and priorities that we're setting and the information we've gathered about our basin. I liked Mary's question about who should sit at the table. And all I can do when I sit at the table is tell you that the laws now give you the power to integrate these areas. But it's up to you to envision how you want to do it. And so I encourage you to all come and sit at the table.
Thank you very much, Michelle. And now we're going to have a little Q&A roundtable discussion with Michelle and Mary and Alan. And so we'll bring them back up here, get the podium moved. And this is really designed mainly to be a Q&A and discussion session. So please think of your questions. And I'm going to kick it off here by asking a simple question really to all of you, which is, Alan, you referred to the kind of Band-Aid approach and this patchwork of regulations that we have. Mary, you talked about some of the issues with exempt wells in particular. Michelle, you talked about models from other places. I mean, if there's one thing that we could do to improve the land use regime from a legislative standpoint, I mean, if you could, if you were the governor and you had a one law to propose to the legislature, what would that be?
That is not a fair question. Choosing one thing would be very difficult. I would choose one policy, and that it would be to evaluate the multiplicity of ways that we have to undertake every planning effort and simplify them. Let's stop having 3 ways to do zoning. Let's have one way to do zoning. Let's have one mechanism for annexation. Let's have one mechanism for subdivision review. So we're not spending all of our time trying to figure out which code we're under, which public notification process to go through. Wouldn't it be so much better for us to all know, if we're going to do zoning, this is what the process is, and not have to ask attorneys and legislators and get attorney general opinions to figure out how the code is supposed to be read, but instead be able to go to those codes, read them for ourselves, and come to a reasonable understanding of what it is that we have to do to accomplish the very necessary tasks that both Michelle and Mary are talking about.
Mary?
I think it's on. I think the one thing that I would suggest is to have an ongoing interim water policy committee. Through the Montana legislature, there's the EQC, the Environmental Quality Council. They've taken on environmental issues from time to time, but I think in the 80s there was a policy committee that was made up of legislators. They invited in interest groups, agencies participated, and there was a cadre of people who understood water law, who understood the changing needs, who understood sort of the basics of development, agriculture, and so on. That water policy committee was disbanded in the 90s, and now we have one again, and I really think that many of our challenges come from the fact that we're not all talking the same language, and that there aren't people in agencies or in interest groups or even in communities who really understand all the ramifications and the impacts. So I think having a forum for ongoing discussion and policy making is really critical.
Money for local government planning.
Money for local government planning. All right, that's a good one. Very, very specific. Do we have questions, comments? Courtney and Matt are there with the microphone, so just put your hand up.
I grabbed the microphone right away from Courtney. I'm Brianna Randall. I work with the Clark Fork Coalition. And my question is on water availability and the exempt wells, or the individual wells that went in. The last conference I was at, the number thrown out was that 7,500 of the 10,000 lots went in on individual wells. That means they didn't undergo any public permitting process and got free water, as Mary said. And also recognizing that it is now, especially with House Bill 831, it is a lengthy and complex and really not fun process to get a groundwater permit in a closed basin. How do we incentivize the people in this room, the developers, and the attorneys and the people who are extracting water, how do we give them an incentive to hook up to a community system and do a permit, make sure that they're accountable to the public for what water they're taking out? Because the regulations, does it have to be regulatory? Are there incentives that are not regulatory to encourage people to hook up to community septics and water supply systems?
I guess that's probably my question. I'm not sure that that's quite what the number is of the exempt wells, given the numbers of lots. If you look at the chart, there is, I think, a pretty good indication, and it is fairly high, the numbers of exempt wells that are being used now for subdivision. As far as incentives, I guess in my mind there needs to be better coordination between the developer, the local county commission, the local planning committee, and the state, both DNRC and DEQ. I know we're working a lot with DEQ because our processes aren't necessarily complementary to each other. So we have work to do there, and we're doing that work right now. So I think that the incentive there may be that more expedited process or a clearer process. But I think regardless, as things become more complex, there have to be processes that sometimes are challenging and maybe expensive in some ways. And I don't think we're going to get away from that. I think that the challenges that we faced are really substantial enough that we're going to have to go through a complex set of maybe even rules and regulations, including maybe some incentives in the long run, because we are faced with so much rapid development.
Well, and just to kind of push that point a little bit, I mean, if you think about the exempt well thing, you know, obviously that was created for a couple of reasons. I mean, mostly it was rural areas that were involved. Also, there is a kind of presumption that if you own the land, you can drill a well on your land. But that was not ever designed, presumably, as a water supply solution for, you know, subdivisions of hundreds of houses. So, I mean, this is probably heresy for a lot of people, but I mean, wouldn't the obvious way to address that be to just say, you know, exempt wells do not apply on a larger subdivision?
I would like to say at this point in time is that we do not have the resources to process permits. If every subdivision had to go through the process for a community well, we do not have the resources right now, and I'm not sure the legislature would give us those resources, so there'd be even a worse bottleneck. I guess, quite frankly, I see it being the option. This has been thrown out there in various bills, and as a department, we have proposed this, that there are two things that can be done, that there be say 10 lots or more and you have to have a community water system, or to do a de minimis, that it's not 10 acre feet, but it's 35 gallons a minute and perhaps 1 acre foot, so that you're making it a smaller exemption. Those are two things that have been floated out there. But I know even this morning, the real estate industry was there, some of the realtor representatives, and I think that they have been very strongly opposed to either one of those avenues. So I think collaboration, sitting down and trying to really find some solutions that will pass the legislature, can be implemented, and that don't have staggering impacts on our resources, our staff time, and to be able to implement them.
Yeah, over here. And I would, by the way, just before we get to the next question, I would invite any developers in the audience to jump in on this question if you have suggestions as to how to address it. Yeah.
Yeah, Kent Watson, landscape architect here in Missoula. I appreciate all the comments, Alan. You brought up the inconsistencies that we face at jurisdictions and so forth, and how that has to be worked out. And I'm wondering, I'd like to hear from each of you to what extent you think the points that Michelle raised about water perhaps driving the whole growth management area as a basis. I think back to those of you that are familiar with John Wesley Powell, who talked about how the West should be divided and not on land sections that are grids that have no meaning whatsoever with the watersheds and natural drainage patterns. So I'd like to hear from each of you to what extent you think we can begin that process. And obviously the committee that Mary was at this morning is starting that process, but how can we possibly get people that make these decisions, our legislators, et cetera, to understand and appreciate the natural ecosystems upon which this planet is based? And really, water is the basis for that.
There's multiple layers to figuring out any of this system, and the first is a recognition of the important role that private property rights play. That seems to be a heightened sense in the West about property rights, that it is not possible to say to your next door neighbor, you do not get to do what I got to do because I got here first. And so when we talk about conserving water and taking hard looks at water and all of those things, it starts with the basis of saying, how do we respect private property rights in that avenue? And at some point, we're going to have to say, you don't have enough water to make this work, or you have wildlife concerns that are too high, or you have wetland resources, or you're just too darn far away from somewhere else, and you can't do it. Well, then you start raising a whole host of Supreme Court case law that says that total devaluation of a property is illegal taking, whether by regulatory measures or actual occupation of your property, it's a taking. So we're going to have to figure out a financial scheme that will pay landowners not to do things. That's a broader global look that we're going to have to get our legislature behind funding these protection mechanisms. But specific to water, the first thing we need to do is finish the adjudication process. We need to know what's out there, and we don't know what's out there. And a lot of you may be shocked by what Mary says, that we just funded, gave a lot more funding to that system, and hopefully in 10 to 15 years, it looks like we'll have all of that figured out. That's short compared to how long of a process it's been trying to get to where we are today. I hope the legislature every 2 years is going to continue to recognize the urgency to figure out what's out there. I don't know how we figure out how we allocate and use what's there until we figure out that adjudication process. So I would bump that up much higher on the list of things that need to be accomplished in Montana, so we can start going to the point of saying, okay, there's X quantity of water here. How valuable is that to me as the developer to go out and buy the rights from all of these other folks? So you balance the system by creating a market for those water rights. Where does an incentive come from? The question over here was, you make it easier to change the points of diversion, change the place of use, change the type of use. If what we're doing is we've quantified the number of rights, and then we're just talking about how we use those rights, we make it easier to switch between uses, whether that's in-stream flows to protect the stream, or it's augmentation to allow the new subdivision to go in place. And one thing I challenge Jonathan about here is we tend to look at water as being, the cities have figured it out, so we don't really have to worry about them. It's all of these thousands of new wells that are going in that are creating the problem. The vast majority of Missoula's water serving the urban residents of Missoula is groundwater. And that's having a significant effect on water rights in the entire basin that serves Missoula as well, because as we continue to grow, we're going to need to go out and get augmentation rights for Mountain Water Company to be able to continue to serve all of us. And so it isn't just we got to figure out something to do with the rural area. We got to know what's out there so we can figure out how the cities are going to deal with it as well. That almost sounds a little more gloom and doom, that I don't mean it to be that way.
Just briefly, I would agree with the water marketing scheme. I think that we need to develop, perhaps with cooperation from the legislature, but this can also be done, I think, between private groups, a water marketing scheme of some sort. That is another thing that the Water Quality, Interim Water Committee is looking at. And I think the sooner the better. As far as the prior appropriation doctrine ever being thrown out, it's just not going to happen, because water is a property right. And I think we need to live within that, and I think we need to very quickly look at creative ways to use water beneficially, which we have to legally. I've heard suggestions of prioritization of beneficial use. That would obviously be a legislative matter. But I think the use of water marketing is a very valid way to go. I also think that to streamline the process for changes of point of diversion and that sort of thing, anything you do with water is going to have an impact on somebody else. And part of that is the objection process that I know can be sticky at times, but I still think that water is a public entity, and we should have the opportunity to object if we think we're going to be impacted by a change in water use.
And how about the definition of beneficial use? I mean, isn't that one of the issues as well?
There are definitions for beneficial use, and water has to be put to a beneficial use. And times there are challenges, court challenges, even within our hearings unit, that it's not being put to beneficial use, which would be for domestic use, irrigation, fishery uses, as well as for industrial uses. But they are not prioritized at this time. Municipalities do not trump irrigation. And so there has been discussion of that. I'm not going to say that I lean one way or another, but I think it's a discussion worth having.
Oliver.
I'm Sharon Haugen, and I'm from the city of Helena. And we have been discussing about water quantity for the most part in individual wells. Well, for the other part of that equation is septic tanks, because oftentimes individual wells accompany septic tanks. I guess I would like to hear from the panel if they have any thoughts in terms of some of the efforts to get DEQ and other entities to look at the minimum lot size, because many would argue the minimum lot size of 1 acre for well and septic tanks has more to have caused the sprawl in Montana than almost anything else. And often when we look at DEQ regulating water quality, they look at the point sources such as municipal plants, wastewater plants, but they do not look at agriculture, they do not look at septic tanks, and they are as much of a contributor to the problem. So I was wondering if anybody on the panel would care to talk about that at all, or if they even see that as an issue.
I wish that Richard Opper, who is the director of DEQ, were here, because he has very strong opinions in septic tanks and setbacks and that the need for larger lot sizes. But I'm not going to comment on that.
I guess from a legal perspective, and I don't work in the DEQ arena either, but from a legal perspective, some of these exceptions that exist in the law, I believe, are going to be challenged. I think the Montana Environmental Information Center case gives us a very clear roadmap into how some of these exceptions can be challenged if they don't have a strong basis, a government basis for why that is the lot, why they picked that particular lot size for an exception. Then I think there are groups that are going to start challenging them and forcing the agencies to reassess and forcing the legislature to reassess the scope of the exception and whether it's really an appropriate number to put on the exception.
Sharon, I share your concern. I think you're exactly right. I think the 1 acre lot size has done more. Well, there's a combination of things. One is the 1 acre lot size really has most to do with if you have the proper separation distances to allow your well and your septic tank and your structures to all be offset by an appropriate distance. Those are made-up numbers, really. I mean, they have a little bit of science behind them, but they're made-up numbers. Here's what's driving it even more, is we make it difficult to do a community system. Now, it's a whole other policy debate to decide whether or not individual septic systems or a community septic system are going to be better, but let me give you an example. When you do a non-degradation review for individual septic systems, they use a flat rate of 200 gallons no matter what size the house is. So 200 gallons per day is the number you pop into your non-degradation analysis. When you go to a community system, all of a sudden they base it on the number of bedrooms. And a bedroom is anything that might in the future look like something where someone ought to live or could live. And so it's a huge difference. So you can put about 14 3 to 4 bedroom homes on a community system, do the math, and that's going to get you to about 4,900 gallons of flow per day. When you hit 5,000 gallons of flow per day on that community septic system, you suddenly have to have a discharge permit. That discharge permit throws out the 200 gallons per day calculation for your non-degradation review and starts going based on bedroom size. So you can put 15 septic systems, individual ones, on 1 acre lot, and you just have standard analysis using a 200 flow per day. Or you can try to do what a lot of people think is better. You put those 15 houses on a community septic system, so you have one. So there's only one to take care of, one to fail, one to fix, one to monitor. But if you do 15 on that, and and they're 4-bedroom, 5-bedroom homes, all of a sudden you're using 350 to 400 gallons per day for your analysis. It completely kills your non-degradation analysis, and the incentive is, I can't do that, I'd better just go with the individual lots and the individual septic systems. So it's a bigger problem than just the 1 acre lot size.
Other questions, comments? Well, I've always got questions, so I'll ask some more. Oh, here. One in the middle here.
This question may be better reserved for another session, but I'll ask it now.
Can you identify yourself? Sorry.
Oh, my name is Angela Bolton. I'm with the Missoula County Planning Department. But I have spent part of my life in California and part of my life in Montana. And I like to think that I've absorbed the good qualities of both. But to what extent do you think the legislature is sort of doing a piecemeal approximation to CEQA with its amendments to the Subdivision Act?
CEQA?
Oh boy. The California Environmental Quality Act that guides how developments or projects are reviewed and permitted and allowed.
I practice exclusively in Montana. I have no idea what CEQA is for California.
Okay, well, maybe I will reserve that question for another session.
So was your question, how does the Montana law follow or not follow what's been done in California?
Right, well, CEQA requires that anything that constitutes a project go follow a certain process and certain areas of resource that need to be addressed. So whenever anything is, any development is proposed, it has to go through 7 categories of review, including water resources, impacts to water resources, aesthetics, socioeconomic, biological, traffic and transportation.
We don't do that
Well,
here.
and that sounds a little bit like the sort of more coordinated approach that you were advocating, Alan, in terms
Well,
of
it's similar to
having
MEPA.
lots of laws, that talk to each other.
In Montana, the analogous thing would be the MEPA, the Montana Environmental Policy Act. And we don't do that for subdivisions, but we have a corollary in subdivisions that requires you to do an environmental impact assessment, and included in that it's not an impact, it's environmental assessment, and included in that is a community impact report. The community impact report is your estimation of the impacts that are going to be created by the subdivision, mainly dealing with things like local services, but the broader spectrum of the environmental assessment are evaluations of effects on natural environment, effects on wildlife, public health and safety, local services, all of those things. So it's not a MEPA style or a NEPA style review. It is much less of a review, and in fact there are some challenges in Montana, court challenges, that are suggesting that the Montana Subdivision and Platting Act is unconstitutional because it violates Montanans' constitutional right for a clean and healthful environment by not providing for environmental review under MEPA. And it's a terrifying thought that any and all subdivisions would have to go through a full MEPA analysis, would kill the process, and frankly will never be politically acceptable to our legislature to do that.
I guess my comment would be Montana has looked a lot to California for its rules, but I don't get the impression that it did so for the EA in subdivision review in Montana. My guess is that it looked to enabling acts and tried to make a fair approximation in the development context to what MEPA requires.
Anyone in the front here?
I would just like to comment, as Montana, I really don't want to take all the California laws.
The comment was that as a Montanan, she doesn't want to bring the California laws here. Why would that be, do you think?
I don't think they've done as good a job as I think when the planning departments try to implement them here.
Sorry, hang on.
My name is Jerry Fisher. I'm a realtor and I do some development. I don't believe California has done that good a job. And I really resent their trying to bring it here and in particular, if planning departments try to apply the intent of California laws to our processes, which we're struggling enough to deal with, try to get through what we have. I also think the water is for Montanans.
My name is Bill Perrin. One of the things that we're talking about is reform, primarily through the legislature. And I'd be interested in your thoughts in regard, can our citizen legislature, meeting every other year, take on these kinds of tasks? Because I think what we're looking at, the Band-Aid approach, is exactly what we're going to get, because when we get together for 3-4 months, we really can't take on long-term reform. I've seen where they've tried to recodify and try to bring laws together, and that's an extremely difficult process for legislature to do and then get passed, because they just don't have the time to do that. What are your comments?
The alternative is worse. Continuing to do things the way we are with the frustration that we have. But it has happened in the past. 1973 is when Montana adopted the first Subdivision and Platting Act. Before then, you just created lots by deeds or certificate of survey and plats with no governmental review. So there was a huge step taken in 73 to create that act. There was another huge step taken in 1993 to enact significant improvements to that act. And then in 97, there was a massive change in the growth policy. And all of those efforts began by grassroots, behind the scenes, varied interests coming together to try to work on the problem. And the varied interest meaning everybody from the wildlife folks to realtors and developers. The problem that we're doing right now with that process is it's starting to look a little bit too much like regulating by committee. And it isn't, the end result is not getting the critical review before it's enacted and adopted that it deserves by folks who are in the field doing the work and saying, that doesn't quite work. So we need to build that into the process if we're going to do it. I don't think we can do it by 2009. I think we can do it by 2011, and I'm talking about a comprehensive reform of Montana's land use scheme, and we ought to start the grassroots building of that first. There's an inherent tension, and every planner in this room knows this. If you create the document first and you take it out to the public and say, what do you think? They say, why in the hell didn't you involve me in the process? If you go out into the public and you say, we haven't created anything, we'd like your ideas, they'd say, give us something to react to. And so there's that inherent tension of do you lock a few people who've been working on this and understand the system in a room and let them create a model, and then we go out to the legislature and say, to all of the affected groups and start saying, what do you think about this and what do you think about that? Or do you get all those groups together and you take 2 years to figure out, to get all the issues on the list and then start writing? I don't know which of those models is going to be best, but I'd take everybody's suggestions for sure.
I would add quickly to that I think it needs to be a combination of the two. I think that the interest groups need to get together on a regular basis in some sort of a formalized forum. We've done that with water before, and I hope with this interim committee that we'll do the same, and then involve legislators. And again, you need to have a core group of folks that have special interests, and legislators who have the knowledge and the background and the interest as well to be involved, and to have an ongoing process where there can be discussion and then legislation can be brought forward that is well aired and is relatively well agreed upon beforehand. Because I think if there isn't some semblance of agreement or consensus, once it gets to the legislature, it gets shut, it gets just booted right out of the water. So I think there needs to be both the interest groups as well as the legislators involved in ongoing discourse.
And I think if I could I'm sorry, Michelle. I was going to say if I could sort of summarize and answer that the fact of a citizen legislature that meets a few months every 2 years can work if the sort of process is ongoing and the constituents or the people in this room, for example, specifically have kind of done a lot of the work, a lot of the preparation work essentially for those legislative sessions.
And you have to include agencies and local entities as well. They need to be part of the discussion as well, because they have to implement whatever the legislature comes up with.
One more question.
I am Roger Millar. I'm the director of the Missoula Office of Planning and Grants, and I came to Montana from the great progressive state of Idaho. And when I got here and got into the the state enabling legislation in Montana, I was appalled by the micromanagement of local government. You know, we're out west, and what we like to tell the federal government is go away and, by the way, give us all your money. But then at the local level, the zoning, the subdivision and platting, the annexation, et cetera, et cetera, et cetera. In Idaho, you could fit that into 5 pages, double-sided. Here you need a hand truck to carry it around. I hope when we look at fixing the problem and taking a holistic approach that we look at the legislature and providing broad enabling legislation and not trying to apply a one-size-fits-all approach to a state as vast and different as the various regions of Montana are, and let local government decide what works best for that community in the context of a broad enabling, enabling legislation.
Well, thanks, Roger. And I think we will take Michelle Reinhardt, we've been talking about the state legislature, and I know you had your hand up, and since you're a state legislator, I thought I'd let you have the last word here if you want.
Thank you. I'm Michelle Reinhardt, and I'm speaking on behalf of myself and as a state legislator, but I also work for Roger at the Office of Planning and Grants to implement these frustrating laws. And I want to say, as an individual, I think we all agree that there are a lot of areas that are not working, and that we should try to work together to find common ground where we can find agreement on how to make it better so that we can see good design, protect our water, and keep what we love about living here and not kill our golden goose. I also would like to put on the spot Betsy Hands, who is a legislator who is here, JP Pomnikowski, who will be on the panel later, as well as 2 legislators from the Bitterroot who came up, Ray Hawk and Gary McLaren. And I would say we all are responsive to citizens and to everyone from various backgrounds. So you can be mad about the things that we've done, but it's hard to operate in a melting pot. And but I do think we all need a pledge to work collaboratively, and I would like to be a part of that and be at the table and work with all of you to try to implement change, whether it be 2009 or 2011. Thank you.
Thanks, Michelle, and I think that's a great note to go to the break. So thank you very much, Alan, Mary, and Michelle, and we'll be back here in about 20 minutes.